Hey everyone, thank you for joining us for this webinar, Clause for Concern, Contract Provisions You Can't Ignore. My name is Adam Walker. I'm joined by Shushan Barsegyan. We're both attorneys at Full Circle Business Law. We're a boutique business law firm here in Glendale, California. I'm excited to talk to you about contracts. I know we live in a world of contracts as transactional attorneys. We know you're probably trying to avoid living in a world of contracts, but we'd like to talk to you anyway about what a contract is, some provisions typically glossed over, and calling out some of the traps for the unwary in those provisions.
Adam, so we're getting some people still trickling in.
Okay.
You may want to just do a quick introduction again, because when you started your introduction, there was nobody that was actually admitted yet.
Yep.
That was your practice. It's
That
okay.
was my practice, and I crushed it. Now I can't possibly match that again.
Just try.
Okay. So to reiterate, welcome to our webinar, Clause for Concern. These are contract provisions you can't ignore, no matter how hard you try. I'm Adam Walker, joined by Shushan Barsegyan. We're business attorneys at Full Circle Business Law. We'll be talking to you about contracts today. As transactional attorneys, we live in a world of contracts on a daily basis, so we'll call out some provisions that are often glossed over and things to be aware of. So we will get started. Thank you for joining us.
I want to just note that this is a very high level conversation about these clauses, because we could really do entire presentations on each of them. But we wanted to give you at least some tidbits, or the ones that we've been seeing more frequently that are bothering us. And if you have any questions about a deeper dive into it, then we'll have some opportunity at the end, and you can always reach out to us. We'll have our contact information available too. Okay, so what kind of law firm would we be without a legal disclaimer? Obviously, this is informational only. We're not giving you legal advice. If you need legal advice, speak to an attorney. We are not creating an attorney-client relationship by presenting this information, and consult your counsel before acting on any legal information we've provided.
So let's take it down to the basics. What is a contract? How do we know if it's enforceable and binding on the parties? So a contract at its heart is an exchange of promises between parties. And importantly, it's an exchange of promises that each party expects the other to live up to. And that's something the law tries to protect when it can. We want to understand what are the main elements of any validly formed contract, and we spell them out here. The first is capacity. We talk about fitness to enter into an agreement. This is not exercising right before you sign it. This is generally legal fitness. So the ability to be bound to a contract by law. Sometimes this is just being at the age of consent, 18 or older. And sometimes it's about mental capacity, the ability to understand that you're entering into a contract at all. And that's typically a function of age, illness, things like that. Capacity is a high bar when we talk about mental fitness. So the fact that you are inebriated or stressed or we're not paying attention, these are not suitable or sufficient to defeat capacity. So not reading the agreement, not understanding its terms, that's not good enough, right? Contract can still be formed. That does not defeat capacity. Offer and acceptance. So this is the clear communication of an offer by one person with all the material terms and the acceptance of that offer by the other person as it's presented. So we sometimes think of offer and acceptance as mirroring each other. So I put together a lot of this content for a different presentation on the theme of Pee-wee's Big Adventure. So a lot of my illustrations are about the sale of a bicycle. So for example, I'll sell you my bike for $200, cash only, and you pick it up on Friday. And if you tell me sounds good, I'll pay $200 by Venmo, and I'll pick it up next Monday. Do we have offer and acceptance here? We have some of the basic terms, right? The price, the item being purchased, that bike for $200, but the method of payment is different. The date of pickup is different. So it's not quite an acceptance. Instead, it's a counter offer. So what we're looking for is a meeting of the minds, that mirroring between offer and acceptance. So we haven't quite found it in that example. Third element, valid consideration on both sides, is such an interesting aspect of contracts, because what the law requires is for each party to give something up and get something in return. So each party enjoys a benefit and suffers a burden from the transaction. So the simplest transaction, selling this bike, the seller gets $200 but loses a bike in that process, and the buyer gets a bike but sacrifices the $200. It's irrelevant whether the deal is a good deal or not, whether it's a bargain for anyone, so long as the consideration, what's being handed back and forth, is legally sufficient, meaning it's not illusory and it's not something the other party has already received. So the old English common law rule is that consideration needs to be at least as consequential as a peppercorn to be legally sufficient. So, for example, I've got a vintage bike for sale. It's probably worth about $200. And if you tell me, I'll buy it for $20 in a handshake. Sold, and I accept that. That's a bargain, right? So even if I later have seller's remorse, oh, I should have charged more, that $20 is legally sufficient consideration, whether it's a good deal or not, in a vacuum. So nobody is mistaken. There's no fraud or duress. That's what we're looking for with consideration on both sides. So it doesn't matter if the actual value of the bike is far less or far more. Okay, so other situations, I'd like to buy your bike for $200. How about instead of that, I'll just buy your bike for the painting of your fence that I did last week. That's not new consideration, so that would not be a bargain. Or a promise to maybe pay you one day for the bike if I choose to do so, right? That's an illusory promise. So those are examples of a lack of valid consideration. And legality is the fourth element. This is something that should be pretty self-explanatory. You can't enforce a contract if performance under that contract is illegal. So one of the obvious examples, the sale of stolen goods, contracting to kill someone, the contract killer kind of misnomer. Those are not bargains that can be enforced in court. You can't go to court and say, this person didn't kill the person like I told them to, or like I paid them to. That's just not going to be enforceable. You notice at the bottom, I say in writing is not one of these elements. So talking about oral agreements being enforceable, that's often the case. So you don't necessarily need to have things in writing, and we'll get into that on the next slide. So generally, oral contracts are binding, assuming they meet the ordinary elements of enforceability that we just talked about. There are some contracts that the law really wants to get clarity on and says this must be in writing. And this is what we talk about when we think of the Statute of Frauds. The Statute of Frauds, which is captured in a couple different statutory sections, says here are the things that must be in writing. So we have a brief list. It's not exhaustive, but any agreement that cannot be completed in 1 year. There's a lot of real estate transactions that must be in writing as well. The sale of personal property above $500, and various other things that come up from time to time. Some of these are in the family law context. So, for example, the sale of a bike, $200, is below that $500 threshold for the sale of goods. That doesn't need to be in writing. But here's an illustration. I want you to build me a castle 30 stories high. Must that be in writing? Technically, absent other information, other circumstances, no, because I can construct that within 1 year, theoretically, right? If I devote enough resources to it. But what if I were to say, hey, can I pay you to watch my house for the next 18 months? That's not something you can do within 1 year, because 18 months longer than 12 months, of course. So we see these kind of nuances pop up where we'd expect some things to be in writing, but the law does not demand that they be in writing. There are a number of good reasons to put a lot of transactions down on pen and paper and have them signed. But this is what the law requires. Okay, let's talk about the world of baseball, which has a lot of contract issues come up. So according to legend, in the 1940s, the owner of the New York Yankees and the owner of the Boston Red Sox met in a bar one day, and they started to talk about their teams, and they started to drink, and they drank and drank until they were barely coherent. And at some point in the night, they talked about Ted Williams and Joe DiMaggio, the two star players on their respective teams. And they said, what would happen if we just did a 1-for-1 trade? And so they agreed, and they wrote it down on a napkin and signed it. And the next day, owner of the Boston Red Sox says, "This was we can't have this happen." But what if the owner of the New York Yankees wanted to enforce this? So let's go through the elements of a valid contract. Capacity. Sure. Remember, I talked about mental capacity being a very high standard. So the fact that you were drunk, even blackout drunk, is probably not enough to defeat this element. It's probably still, you should probably still have valid capacity there. Offer and acceptance. We clearly understand what's going back and forth between the parties, and they agreed to the material terms, one player for one player. Consideration, sure. Each side gets a benefit and suffers a burden from that. And there's nothing inherently illegal with trading contracts like this, notwithstanding perhaps a modern day collective bargaining agreement or something like that. So if one owner wanted to enforce this, they would take it to court, and we wouldn't see any obvious obstacle to enforcement. Second hypothetical is still in the realm of baseball. Probably Hall of Fame bound player Justin Verlander in high school got thirsty one day, said to his friend, "Can you buy me this chocolate milk for 50 cents? I don't have any change on me. In exchange, I'll let you have 1% of my signing bonus if I get signed by a big league team." So great, they shake hands on that. A couple years later, Justin Verlander gets drafted in the first round for a signing bonus of a little over $3 million. So is this enforceable? Remember, we talked about valid consideration being really doesn't need to be a good bargain for anyone. So that's not the obstacle here, but capacity is, right? These are people who are under the age of 18 when they made this bargain. So that would be the real obstacle, but it gets you thinking about what a valid contract might be under a number of different circumstances.
Okay.
Yeah.
We'll take a little break from that. So I think there's enough information on what a contract is, but we want to get a sense of how familiar you are with the fine print in your own contracts. And we do have a mix of professionals and business owners on the webinar, so I'm curious to see. You should see the poll launched there. If you could please select your answer, that would be really great.
If you're a client, you should choose the "I trust my lawyer" answer.
We'll keep this open for another 15, 20 seconds as we get answers in. Let's see. If you haven't submitted your answer, please do so. There we go. I think we've got, yep, that should be everybody. Okay, so we're seeing here 56% said, "I read every clause." I wonder how many of them are lawyers. But if you're not, great. I'm so happy to hear that. And then 22% said, "I skim until something looks complicated." Okay, that's probably more common, I would say, in most circles. 11% said, "I trust my lawyer." Thank you for listening to us. And another 11% said, "I don't usually look at them unless there's a problem." All right. It's a good way for us to get a sense of how people interact with their contracts. Okay, so now we can jump into some of the provisions that are they have hidden issues within them that people might not think of, or they're not the obvious issues that you might consider. So Adam's going to take us through the first few.
Okay. So we understand contracts now and what the elements are for a valid contract. One of the things we see often, people trying to avoid the costly road of litigation fairly, and we see arbitration provisions in, I'd say, most of the contracts we come to review. The goal of arbitration is to get a binding resolution to something by an arbitrator at a cheaper cost, ideally faster than litigation. And so we agree to go to arbitration as kind of the exclusive method of resolving disputes. That results in perhaps inartfully drafted provisions sometimes. So we'll talk about some of the things we see. So there are challenges even when you have a written agreement in forcing a party into arbitration sometimes. So under most circumstances, the parties who are agreeing to arbitration exchange a list of potential arbitrators or are directed to go with a specific company. So in order to compel someone who's just not answering you, not responding, not agreeing to a date or time for arbitration, you have to petition the court to force them. So that's a potential route that incurs legal fees if you're not on the same page with the party. And remember, we're at a dispute, so it's not clear that you'd be able to have a meeting of the minds with them. If you go to court and the other person does not show up, does not respond to the lawsuit, the court is entitled to enter a default judgment for you, which means you automatically win, and everything you assert is presumed to be correct. There are some litigators on this call. They'll chime, they can comment on that too separately. But in arbitration, you don't have that privilege. So the arbitrator is not going to enter a default judgment for you if the other party doesn't show up. If they stop responding, you still have to present your case regardless of the fact you're only person in the room. So provide evidence to support your entire claim, you prove your liability and damages, and you can still lose, right? So that's on the table. Also, the parties are expected to share arbitration costs, which are sizable. We'll get to that in a second. The other party doesn't show up, you're fronting those costs usually. So, and again, you might not prevail when you do so. It's also not entirely clear that arbitration is going to be cheaper than litigation sometimes. Arbitrations are typically done on a daily basis, in as much as you're paying a daily rate for the services of an arbitrator and the company. That can exceed $10,000 a day. I was talking to a litigator yesterday about a JAMS proceeding she was involved with. JAMS is one of the premier companies, arbitration companies, and their fees were $20,000 a day. So that does not include your attorney fees, who must work up an arbitration brief and you work up that case. It's possible in some scenarios where, especially a claim without merit that's being brought, could be dismissed somewhat easily in court with a motion to dismiss or summary judgment, and could in fact be faster because the court is incentivized to get through the docket than sitting in a full day arbitration or something that extends beyond full day. And so we're talking about tens of thousands of dollars in just arbitration costs alone that might be avoided under certain circumstances. We see arbitration provisions call for a panel of arbitrators sometimes, perhaps 3 arbitrators hearing a matter that might not warrant it. It might be a simple commercial dispute that is $10,000, but there's that arbitration clause that requires arbitration and the duplication of costs by having more than one arbitrator. That's something you're going to want to single out as something worth changing in your contracts if it's in there. And it's not entirely suitable. The arbitration company that's written in the provision is going to be a good fit for you. So they could be extremely expensive. They might have rules on discovery of facts that aren't suitable for you or one of the parties. There could be a perceived bias in favor of big return customers or corporate institutions that ultimately pay the arbitrator fees on a regular basis. It's also possible the company just goes out of business or merges or is acquired by another company. And so that language then becomes stale in your contracts. So I put together this provision that has a couple challenges with it, and I've highlighted those. So we list out a specific arbitration company that might or not be suitable based on their standard rules. And there's a panel of 3 arbitrators. We don't know if this kind of case is sophisticated or complex enough or arcane enough to warrant a panel of arbitrators. Perhaps one is appropriate. Perhaps the parties should make attempts to agree to a more economical way to resolve the dispute.
And I would just add that from our experience with litigators, there are people who just have certain preferences for one company over another, or a certain, arbitrator that has specific experience in a particular industry. And all that to say that these arbitration provisions shouldn't be treated as default provisions that are just included in your contracts. Each one needs to have careful consideration. And I don't think that that's generally the case. I think people just put in sort of a placeholder for arbitration, and that's what ends up in most of their contracts. So just keep that in mind.
So mediation is an informal, non-binding way to resolve a dispute before you get to arbitration or litigation. The goal is to get the parties in the same room with a neutral third-party mediator and hash things out. So attorneys are present, they still draft the same, similar briefs. But it's really a way to get the parties in a room together and try to talk out their issues. Just because it's informal, just because it's non-binding doesn't mean, again, you slot in some standard language and call it a day in the contract. So there are some challenges here that we can talk through as well. Some of this involves the mechanisms, the procedures, and the timing of getting this all squared away. So typically the parties put together their own list of mediators, compare it with the other side, try to mutually agree on what this looks like. We've seen provisions that fail to explain how quickly this process must occur, right? So we'd like there to be language that requires each party to deliver their list of proposed mediators to the other within a specific period of time. Because absent that language, it's unclear, except for a vague duty of good faith and fair dealing. What does this process look like? When is the other party in breach for not delivering their list to you? And what happens if you just can't agree on a mediator and months go by? What is really prompting action? And having something in the agreement to provide some recourse is really helpful. So if one party delivers their list and the other doesn't in 30 days, the party that's performing properly gets to just choose the mediator. Or if they can't agree mutually, maybe having a ranked choice system that can get them closer to a resolution on this. Same thing with date of commencement for the mediation. So you come up with the mediator, what timeline are we on to get this thing actually heard by the mediator? So it's usually silent or proposes a schedule that is maybe not suitable. We like to at least get some term in there so the other parties understand what they're getting into. And if there's undue delay by one side or the other in choosing a date, then the party who's acting in a timely fashion should either say, forget about mediation, now I'm allowed to go to court, and we waive that mediation option. We wouldn't typically expect to go to court to compel mediation because it's non-binding in the first place, but that could also be an option. Similarly, here's a problematic provision I've put together on this. We see that there's no timing element in this section at all. We agree to go to mediation. We agree that each party is bearing its own costs in the mediation, including splitting the mediator costs. But we don't know what happens if the other party just doesn't comply. So we'd expect to add some more teeth to this. So it's not just commercial contracts we're interested in. We're also interested in contracts at the entity level with LLCs or corporations, things that are often built into buy-sell agreements for corporations or operating agreements in LLCs. These are the main documents that explain how the company is governed and what happens if one owner wants to sell and walk away and transfer their interest to a third party. The general rule is you're free to do so. You're free to sell your shares to a third party. And that can be a problem for closely held companies with just a few members who want to keep the core ownership together because there's value in doing that. So we see transfer restrictions placed in these agreements that provide a right of first refusal, as Shushan will talk about later, or otherwise restrict your right to transfer these shares to a total stranger. That's really what we're trying to avoid. But we also don't want to make this so burdensome that you're stuck with shares that you don't want anymore. So we see customarily provisions that allow for transfers under specific pre-approved circumstances. So that's typically to a living trust. You can transfer your shares to a living trust, to a family member, to another company you own, and the other owners don't need to approve that. It's presumed that they grant your approval. It's not necessary. That comes with a lot of challenges as well. We'll get to that in the next slide. So there are naturally a lot of benefits to having a living trust, putting your equity in a company in that trust to avoid probate. But it's not entirely clear that the trust you're transferring shares to is controlled by the person who's transferring them. We ultimately want that person to still be involved in the business, still making decisions, and not cede their authority to someone that the owners have never met before. For example, a co-trustee who might have authority to bind the trust to the decisions they're making with respect to the shares. So we would want to make sure that transferring owner is the sole trustee or otherwise has the ability to represent the trust in everything that's going on in the company, because otherwise it could complicate the company's decision-making process. We also chafe a little bit at including family members in this conversation at all, because it's not necessarily the case that these people are interchangeable. You have an owner who's been in the company for 10, 20 years. There's a provision that allows them to sell their shares to a spouse, to a sibling, to a child, without needing approval by the other owners. And it's not entirely clear that that transferee is going to have an interest in running the business, is going to have expertise, it's going to have the same vision, or even the same license. In many cases in California, for professional corporations, all shareholders have to be licensed in a certain way. So law firms, doctors' offices, therapy practices. These all come into play. So it's possible the transferee cannot be qualified to take those shares, and that needs to be accounted to. But also businesses that have liquor licenses or other licenses affixed to the fundamental aspects of the business. And we need to make sure everyone is qualified to hold those shares. So we'd like to see changes there. We want to make sure if you are transferring your shares to another entity that you own that entity now for the foreseeable future, and that where that company is voting shares of this company, the authorized representative remains that person, right? We want them to be engaged. So for example, owner in company A might have a wholly owned business that they'd prefer to own the shares of company A in. Keyword here is wholly owned. So we understand, we know who we're interacting with on the other side. If they lose control over that other business, who knows who you end up working with in the core business. So that's something on our radars as well.
I want to just add, if you have any questions during the duration of this presentation, please feel free to put it in the chat or in there's a Q&A section, I believe, that you should all be able to have access to. We won't answer them as we go, but we will answer them at the end of the presentation.
Okay, so here's a problematic provision which hits on kind of all the elements I just talked about. So you're allowed to transfer your interest in an LLC or you're stock in a company without anyone else's approval here to a living trust. No comment on whether you control the direction of that trust as the sole trustee. You can transfer to a corporation that you own, but it's a little ambiguous because you could own 100%, you can own 20%. What's really at stake, and who's going to be controlling those shares when it comes time to vote? And I think most problematic here is transferring shares to a family member, where family member means immediate family, including but not limited to a spouse, sibling, child. So not only do we not know if this person actually wants those shares or is qualified to run the business or vote those shares, but it's not even an exhaustive list because immediate family member is expansive. It includes and is not limited to these people. So who knows who you will end up doing business with if a transfer does occur, and you will have had no say in the transfer. Okay, so I'm going to hand it over to Shushan now to talk about indemnification and other matters that come up.
Yeah, so this is a good way to segue because we're still talking about organizational documents, and I'm going to focus on indemnification in organizational documents, not indemnification in commercial contracts, because they are pretty different and they're drafted a little differently too. So what is indemnification? Often for corporations and LLCs, the company will agree to indemnify, to hold harmless, or to cover the costs and liabilities of its members, its directors, its officers, managers, and other people that are acting on behalf of the company in some sort of like agent capacity. And these clauses typically include the advancement of expenses, though this varies based on organization and what they want to accomplish. So that's what indemnification is. What are the hidden issues with indemnification provisions? There can be many because these provisions can be drafted very, very well or very poorly. So there are a lot of issues that can come up. The ones I've highlighted are the ones that I think are the most important to most companies and owners. So insufficiently defining who is covered by indemnification. I mentioned a few of the big categories, right? Members for LLCs, managers, and then in the corporate context, directors and officers for either, really. What happens is when we don't define officers, for example, we can be overly inclusive or under inclusive. So how are you overly inclusive by not defining officers? Imagine a company that has 100 VPs, right? A lot of the studios, for example, everybody is a VP of something. Is the intent for the company to indemnify all of those vice presidents because they all sound like officers? Or is the intent really to indemnify certain levels of officers, the chief executives? So this can leave things open where a company ends up indemnifying a team member that they didn't actually anticipate or intend to indemnify. The other is dropping people off. So especially in closely held organizations where we're confining the covered persons to owners and managers in the LLC context, not like the manager of a store, then you run the risk of leaving off a key employee, for example, who doesn't hold an officer title, isn't a director, isn't an owner. So it's important to clearly define who the covered persons are in an indemnification provision. And why is indemnification important to the people working for an organization? Because it provides them with security, right? They're risking their own liability by acting on behalf of the company. They're risking being sued by third parties for their work on behalf of a company. They want to know that they're going to be secure and defended by the company if that happens, and that their costs and liabilities will be covered. The other is having permissive versus mandatory language in an indemnification clause. So there's no statutory requirement, at least for LLCs, to indemnify their members and officers. There's some mandatory language for corporations, but they're under limited circumstances. So this means that the contract itself needs to identify whether this is a mandatory provision. If the company shall indemnify its members, shall indemnify its directors. If it says the company may, then it defeats the purpose, right? And I've seen this happen a lot where it says may, especially in standardized default provisions. We want to make sure that our members, our participants know for sure that they're going to get the benefit of indemnification. So we want that to be clear. And the other thing is, if there's a condition to indemnification, like success on the merits, right? We'll indemnify you if you win ultimately. Then we want to really define what success looks like, especially in a settlement context, because most lawsuits don't end up going to trial or don't get a final judgment. They're settled outside of court. So what does it mean to really be successful? And lastly, the advancement on expenses. Because this is completely discretionary, we want to be clear on whether we will advance these expenses or we're going to just cover them after the fact. And then to what extent will there be a cap on those expenses? So these are some things that we want to make sure drafting the language is very clear and precise. Okay, now on to the right of first refusal. Again, what is right of first refusal? This is in the context of purchase and sale of shares or LLC interests. So if I'm a member of an LLC and I want to sell my interest to a third party, someone who's not already a member of my company, and my company and fellow members have a right of first refusal, that means I have to bring them the option to purchase my interests first before I can sell to somebody else. And it's usually on the same terms. And this is really great to keep that closely held, the control of the company in closely held businesses. What I'm concerned about is the timing of the options and exercising them. So some of these provisions have just standard timelines that aren't really well thought out and don't consider the realities of what it's like to actually go through a purchase or sale. And then sometimes they don't have any timeframes at all. It's just the company has an option, the member has the option. So we want to avoid that situation. Now consider this example. I'm not going to read the whole provision, but the main part I want to bring attention to is that the company and or members, already ambiguous because we don't know who gets that option first, shall have 30 days from the date of delivery of written notice to elect to purchase the interest. Okay, sounds reasonable enough. 30 days is enough time to be able to give notice to elect that purchase. If no election is made within the 30-day period, then the transferring member may proceed with the sale to that original third party, provided the sale is consummated within 60 days of the expiration of the election period. This is where it becomes concerning because in most instances, when there's a third-party buyer, that third-party buyer has to secure financing in some way to make the purchase. They have to conduct diligence on the company and what they're getting into. That can take time. So securing financing, depending on the kind of financing, but if it's an SBA loan, it can take more than 30 days just to get the financing. Diligence often takes several weeks to several months, depending on the complexity of the business. If there are regulatory approvals that we need, earlier Adam mentioned we might have a business that has a liquor license. So if there's a change of control, we have to get approval from the regulatory body. All of these things can delay the timeline of purchase. And that means that there's no way that this third-party buyer is going to consummate and complete the purchase within 60 days. And what happens when that's the case is that that waiver of the option could be voided. So where the transferring party got the company and the members go ahead, they said, we're not going to exercise our option. If it falls apart within 60 days or we don't complete within 60 days, then the option goes back and we start this process all over again. So again, this doesn't reflect the realities of how purchases move through the pipeline. So what should you do? It's really important that at the outset of drafting these provisions, we take into consideration the company's size, what the industry is. Are they going to have to deal with regulatory issues? Who the likely buyers are? And if the company might actually exercise an option, will it have the financing available to exercise that option? Will they need extra time? So these are all different factors that need to be considered before putting in just standardized timelines for the purchase of sales and for the right of first refusal. Now, again, kind of in the vein of purchases and sales, dealing with M&A, I've seen a few things come up, and this was really the impetus of the webinar, because confidentiality and assignment clauses have really limiting language. So confidentiality provisions generally say, you can't share any of the information I give you. Sometimes that includes the agreement itself or the relationship. You can't share that with anyone unless I approve that or consent to it. And for the assignment piece, it says that you can't assign the contract that we have together. Let's say I'm your client and you have a contract with me. You can't just give that contract to someone else. You have to get my consent. So these are all limiting factors, and there's no carve out for mergers or acquisitions or change of control transactions. Often there's no carve out for that. This can create a delay in diligence or during diligence, and it can even stop the entire M&A deal if the carve out isn't obtained at some point. So what do you want to look out for with confidentiality clauses? The theme here is no carve outs, right? So if there's no carve out for disclosures to potential buyers or investors, that means you're going to have to go get consent from the other party when this comes up. A lot of companies that we work with have some sort of exit plan in mind. So they think that at some point they may either get an investor or they might sell and completely exit. If that's the case, each contract that an entity, a company signs should look at the confidentiality clause to make sure that there's a carve out for these kinds of scenarios, because they're going to be more likely to come up. If there is a carve out, Sometimes it's a very broad need to know standard, and it doesn't cover all of the possible participants in that M&A process. So you want to make sure that if you know you're going to have certain advisors that will need access to these contracts or to the information that you have, then they should be included in the carve out. And watch out for those remedies too, because if you violate a confidentiality clause, often there's injunctive relief, which means that the other party can stop you from disclosing that information. So all of this is to avoid anything that's going to stall or kill a deal that you're already moving forward with. And the same is true with assignment clauses. Again, that no assignment without consent language, that can be a problem. A lot of value in service businesses come from customer contracts and certain key contracts. So if you can't assign those contracts to your ultimate buyer, it impacts the value of your business. Or imagine a scenario where you have, let's say, 100 different contracts that you want to assign. Now you have to go to each one of those parties and obtain their written consent to assign the contracts to the new buyer. Not only is that a headache, you may not be able to get everyone's consent, and that could again impact the value of the business that you're selling. One thing to look out for is that some clauses treat change of control as an assignment. This is particularly true with promissory notes or loan documents, but it can come up in other commercial contracts too. So a change of control could be you sell 25% of the company's shares to someone else, and it's now a different composition of ownership. That could potentially trigger an assignment, and you could be in breach of your contract. So you want to look for those clauses too. The solution is simple yet not simple, because you have to negotiate these carve-outs in advance so that you're not leaving it to the final days of a transaction, scrambling, trying to get people's consent. Negotiate it in advance, and hopefully you'll be able to come to some sort of agreement where the language will cover you, but it still gives the other party enough security where you're not going around and just disclosing things to people that they didn't intend. Okay, that's really all of the clauses we want to talk about for today. But I'm curious now, having listened to some of the issues that can come up, if you could fix one clause in your contracts tomorrow, what would it be? So I'm going to launch.
Maybe just about what do I want to look over again and address, given what we talked about.
Right.
And maybe you find you have to fix something.
So I'm just curious, we'll leave this open for a few minutes. If you want to type in something, that would be really helpful for us to see what you took from that. And then if you want a contract audit, you can just drop an I do in the chat. We'll follow up with you. Otherwise, we want to open it up to questions. If you've got any, we'd love to take them. And if you're not comfortable putting it in the chat or putting it in the Q&A, you can reach out to us afterwards as well. We're happy to talk about any of these. Okay, Adam, do you have anything you want to add?
No, thanks for taking the time and learning more about contracts and things to be aware of. We suspect now you'll race back. This is your top priority. Race back and look at the contracts you have in place to see what pitfalls there might be, or now you just have more awareness of what you should be considering as you look through any contract.
Yeah. So we are going to have the webinar on our website at some point. And once we do, you can go ahead and access that through our website. Again, if you ever want to look back at this or you have a question about something, you'll have access to it then too. All right. Well, thank you all for participating in our webinar with us and attending. And we hope that you took something out of it, at least one nugget that you didn't have before. And we look forward to discussing some of that with you offline. Thank you all.